চেম্বার থেকে ফাইল এনেছো বুঝা না কপি করতে আসছে 91 41
Milord, may I leave to mention a matter, Milord? Milord, this is appearing item number 131. Milord, on the last occasion, when the matter was taken up on 10th April 2025, Your Lordship passed an order whether petitioner has earned an increment on 31st July 1997 from his erstwhile employer railway or not, is issue which required learned counsel to ascertain. A matter was fixed on 17th April. So it can be
What do you
upgraded.
want? No, no upgradation.
Upgraded, Milord.
Sorry,
It's a motion, Milord.
no.
A motion stage. But this is motion speech, bro.
Yes. Well,
Well, I mentioned one motion for inclusion.
inclusions you may give.
Milord, this can be upgraded, Milord.
Sorry, sir, not.
Milord, there is
No
another
upgradation.
matter, Milord,
Yes.
where this court directed the matter will on the returnable date will appear. It did not appear, your lordship.
Give it, they will check.
Because the item number 4, when the advocate for the respondents is there, I wanted adjournment because the learned senior counsel couldn't come today due to the spinal surgery.
Not today.
And can you fix it tomorrow at 2 p.m.?
Not today. Call the list.
Cha.
Responded already direct compliance. Maybe fix that to be mentioned.
What is it? Who are you representing? Then
I made there is direction already made.
has been complied. So you inform the petitioner.
I also informed to the
How can you mention it is the petitioner's case? He has to mention. Let him mention. Tell him. Yeah. Next. Call the list.
Tablet, sir, item number 1.
Next.
Item 2.
oh sorry.
3.
My lord, I'm from the respondent side. My learned senior is not available today. Kindly not for today. The matter.
You are for the petitioner. Not today.
Item 5.
Item 5, appearing for the petition led by Mr. Kollol Vasu. He's appearing virtually.
Millet, today I received a phone call from Mrs. Sonal Sinha. Millet, her son is not well, Millet, and she was suffering from Millet personal difficulty. Mrs. Sonal Sinha appearing for the respondent. She called me up. কি পজিশনে
এই তো অলরেডি দিল
কেন তো সিদ্ধান্তটি
পাঠিয়েছি
Yes.
Millet, file is not here also listed, Miller, that is printed. And number 1 and number 2, that Mrs. Sonal Sinha, she is the learned counsel representing the state respondents. She called me up today, Miller, and expressed her personal difficulty on account of her son's illness. So, Miller, this is the tradition of the bar, Miller, the personal difficulty of a lawyer, Miller. If your lordship takes it up, Miller, day after tomorrow, subject to convenience. The file is not here also.
No, file will come in 2 minutes. Don't worry about that. You can start. They are getting the file.
Oh, and Miller, the second reason is this, Miller, I am informing your lordships. If your lordship takes it up, day after tomorrow.
Yes, as it is submitted that there is personal difficulty of the Learned State Council. Today, matter is adjourned to give the date of day after tomorrow.
Extremely grateful. I bow down to you.
Grateful, my lord.
Item number 6.
But kindly see the last order on last occasion. The petition have retired on 31st March 2022.
আমার কাছে একটা ছিল ডাকছি কিন্তু যেটা যে ট্রেনের কত নম্বর ওইদিকে রইবে
was appearing in item number
But kindly see the last order. On last occasion, your lordship was pleased to direct the state respondents to file a report because they have submitted their disciplinary proceedings pending. Whereas in the order impugned, it has specifically recorded that no disciplinary proceedings or criminal proceeding is pending against the petitioner. And the petitioner retired on 31st March 2022. Till now, no pension has been disbursed. And one more thing, last occasion state file a report, I wanted to file my exceptions against that report.
Like copy may be copy may be given to us, my lord.
Yes, I'm sir.
Now, my lord, his lordship on the last occasion has asked us, my lord, to disclose the details of the, my junior, yes, my lord. My junior has told me that he has repeated occasion asked the concerned department to supply those so that I can produce it before his lordship. Till date, my lord, nothing has been handed over to him, my lord. But my lord, it has been only mentioned that the disciplinary proceedings is pending. His lordship desire was, my lord, to hand up the detailed of the number of the case pending in which stage.
They are disputing this fact. They say that no proceeding is pending.
But my lord,
Except on internal page 2 of the order input. Part paragraph starts with from the submission and records. Submission and records, it is made clear that neither the criminal case nor any disciplinary proceedings are pending against the applicant. It is specifically recorded that. By 31st March 2022, I have prepared from service. Still now, my lord, no pension has been disbursed. Pension, gratuity, nothing. Filed my affidavit of asset for last 3 years for vigilance. Though vigilance clearance was not the requirement of my lord, the AG Bengal, they have only said that whether it is pending or not. But in spite of that, I have submitted all these documents within the stipulated time specified in the impugned order. And that I have got the next also with my lord writ petition. As on today, there is no bar for refund or disbursement of pension. Pension is my right. 2022, I am fighting, my lord, but till today, no pension has been disbursed. Even not only pension, since 2003, no salary has been disbursed in favor of the petitioner.
Why have you assailed the order of the tribunal? The tribunal has only said that you provide the whatever they are asking you and it will be.
Next year, Lord, should kindly come to.
You have provided your asset declaration statement. When? Where is that?
That page 38 of my writ petition. That has the stipulated time specified by the tribunal. 39 and 40.
So now what remains? If they are not complying, then you file a contempt before the tribunal.
If I go for the tribunal for a contempt proceeding, then again I have to wait for 2 years or 3 years.
So every case, the contempt, instead of contempt, we should take up a writ petition.
Kindly takes up one thing, kindly takes up my supplementary affidavit once.
No, we are saying when you have complied with the order, then why you are here? This is not a substitute for or a fast track for the tribunal.
They have claimed for my asset.
The issue before us is that you were required to do some formality for facilitating grant of pension. You say you have completed the formality, they are not acting in terms of the order. So what are we to do? You go for contempt.
Kindly takes up page 24 once of my supplementary affidavit. This is the letter of my AG Bengal. That is my 14th October 2022. Now they just want to know the AG Bengal. What
That has no relevance today. There is an order of 25. That order you have already complied. Forget about 22.
One thing, what the thing is going on is today that the AG Bengal wants to know whether any vigilance.
We don't know. That's not the issue before us. That is not the issue before us. Sir, that is not the issue before us. You are arguing something which is not relevant. No, you are not. You have obtained an order from the tribunal. You have complied. They are not doing it. The remedy is before you. You choose not to get it implemented. Then what can be done?
The difficulty is I am running from post to plus.
You are not, sir.
My pension, which is my right.
You are coming to the see whatever your right. That is not an issue now. That is already decided. These submissions are irrelevant today. You have obtained an direction from the tribunal. You get it complied. So for every case after a direction by the tribunal, the High Court should take up the writ petition to get it complied. Then that will be the.
So that the
We don't know. We don't know. We don't know. We don't know. We are not here to answer that. We are here to see the order as it is. You have complied with the order. You are. Then what remains? You go for contempt.
I have complied.
When did you comply? You have filed in February.
Yes. As per my in my report, Milord, in paragraph 13, Milord, I have mentioned, Milord, if Lordship takes paragraph 13 once, Milord. In compliance with the order dated 31 passed by the Administrative Tribunal, the petitioner had submitted the asset declaration statement for the last 3 years to the Superintendent Engineering Purulia by letter dated 12/2/2025.
Yes.
Thereafter, a proposal along with the relevant documents were forwarded to the Office of the Director of Health Services, West Bengal, seeking requisite vigilance clearance. Thereafter, in paragraph 14, what I have stated, it is stated that in addition to the above, latest information as have been received from the Office of the Joint Secretary Vigilance, Department of Health and Family Welfare, is that there is a departmental proceedings pending against the petitioner since 2014.
Every day they are coming with a new.
No, I have not come up with a new case. Today morning, Milord, today morning, this document was handed over to me, Milord. The note sheet, Milord. Now, read that second page, Milord. I have read that. Now, this is today morning, Milord. It has been emailed to my junior, Milord. Now an application being WPST so-and-so, Anil Kumar Gupta and so-and-so is arising before the Honorable High Court. It appears that an order dated so-and-so passed by the Honorable High Court has been placed so-and-so for kind perusal reference wherein Honorable Court Calcutta has directed the Learned Council State place the record of the details of the pending governmental proceedings, if any, to justify the payment of provisional pension. Vigilance clearance for retirement benefit in favor of the so-and-so cannot be accorded at this point of time due to pendency of the departmental time. And again, Millard, only things, Millard, they knows, Millard, I have that has been in their note sheet as an unauthorized absence from 6/8/2023 to 9/8 19/8/23 5 6 years. Millard.
How can you be permitted to take such a stand? It is recorded in the tribunal stand that there is no proceeding pending. You have not challenged the order. That is a fact which is recorded. You are only required to comply. And for that compliance, they have a remedy. You will be hauled up for contempt. You see, it has been specifically recorded in the tribunal's order. The second page.
It has been mentioned, Millard, paragraph 2, Millard, from the submissions and records. It has made clear that neither
It has been made clear to the tribunal from both these things. Then this is a fact recorded.
However, he has asked to furnish so and so.
Therefore, whatever was remaining, the tribunal has said you do it. You give the 3 years statement, and thereafter they will process in a time frame. That time frame, if he wants to get enforced, he can get it enforced. How can you be permitted now to raise this new issue? Unless you had challenged the order of the tribunal, then of course the issue would be different.
It has been mentioned, Millard, in the final portion, Millard.
Yes.
And similar, after hearing the submission and considering the facts and circumstances of the case, this application is disposed of by directing the applicant to furnish within 1 month from the date from today the asset statement for the last 3 years of his service before the respondent number 5, the so-and-so. Upon receipt of the asset declaration statement from the applicant, the added respondent number 5, the superintendent shall submit a proposal with the documents to the respondent number 2, the Director of Health Services, within 3 weeks from the date of submission of the statement by the applicant. The respondent number 2, Director of Health Services, shall initiate suitable action upon receipt of the statements from the superintendent for proceeding his vigilance clearance within 3 weeks from the date of submission of the superintendent. So, my lord, everything has been done. Now, my lord, thereafter, the respondent number 5, the superintendent so-and-so Purulia process his pension proposal. Once such vigilance clearance has been accorded in favor of the applicant within 4 weeks from the date of receipt of the vigilance clearance. In my note sheet, my lord, I have specifically stated, my lord, in terms of this tribunal's order, my lord, we have forwarded everything for the vigilance clearance. But now the problem is, my lord, the vigilance clearance for return so cannot be accorded at this point of time of the departmental proceedings.
Yes.
So, my lord, at this juncture, my lord, we are stuck on this point, my lord.
Whatever it is, you should make him aware of what is pending,
Lordship.
so that he can also take.
Also, my lord, categorically ask them, my lord, they have also knows, my lord. But in spite of repeated requests to me, my junior, everyone, but my lord, that document, that case number, pending date, when commencing, that should have not yet been.
So we are unable to gather an impression that they seriously want to pursue.
Only pleading is there, my lord, that proceedings is pending since 2014. This much has been played in paragraph 30 in my my lord report.
Unless you give it to him, how he can proceed with the matter? You hand over a copy.
I shall.
Nothing can be done. What is wrong with the order? Tell us. Tribunal's order, what is wrong with the tribunal? Huh?
What happened in 2003, I was transferred from
That we have seen. You have been absent for 5-6 years.
6 years.
According to them, according to you, you will say I was not absent. That is something which they have to consider.
Applications have been referred before the tribunal. In none of the applications did come up with a point that there is a discussion.
See, history is immaterial. Again, you are trying to rake up the history which is immaterial. You have approached the tribunal for a particular relief. It has been granted in a particular terms. What is wrong with the order? We are asking you. Tell us, why should we interfere with the order of the tribunal? What is wrong with the tribunal's order? Tell us, why judicial review? There is nothing. You do whatever you want to do. It should not be. Therefore, yes, sorry. You go, whatever remedy you have, you go and avail the remedy. What can be done?
But I was saying that Lord Sabha kindly give me a week's time to give the reply to that. Because a third case has been made out, I have to start.
Why you want time is not relevant. You are entitled to time. You have been granted time. You have still not filed it.
I will proceed, there is no problem.
You have still not done it. You want further time, you say you want further time. Don't
Okay,
say,
week's time.
yes, why you are, as played 1 week, further time is allowed for filing a reply. List after 1 week.
Item number 8.
This matter, I beg to
Item
appear.
number 8, my lord, I appear for the petitioner.
But in this matter, there is a
Doctor,
direction for filing affidavit. When the affidavit is ready, it will be affirmed by in course of today. Can it be taken up? Date?
Can you give it to him today?
It can be affirmed by today. My officers are waiting here.
So you give it to him today
Yes.
during course of the day.
Yes.
Your position is in the process of being filed during course of the day as per submission of the learned AGP. Stop. Let a copy be served on the petitioner accordingly. Stop. On the petitioner's counsel accordingly. Stop. List on Monday. In the meantime, if required, the petitioner would file his reply.
item number 9,
9 के करते हैं।
Why? Every day adjournment. 9 June, 16 June, again today. What is it? Let us see. Why are you taking repeated adjournment?
He died on 5th of June 2008.
Yes.
But at that point of time, his date of birth was 9th October 1994, below 18 years.
9th of October 94.
94 date of birth of the petitioner. 15th of June 2008.
Go to 2008 is how much? It's 14 years. So he was only 14 years at the time of death. So after he attained majority, the application was made or before?
On 30th March 2012. And
That day he was still not a major.
no, still not a major. Then
Huh?
father applied for appointment of her son.
No, but this son only.
This son.
But he was not major even on 33.
Yeah.
If his date of birth is 9-10,
9th October 1994.
then he would attain majority in October 2012, not March.
But application filed on 30th March 2012 and 1st December 2012 with the prescribed form. 1st November 2012.
This case legal.
The gentleman filed an application on 14th October 21 after attaining the age of superation. A good will.
Any order has been passed regarding his claim?
order that
No, prior to that, the authorities, whether they have passed any order.
order to go. The authority passed on 3rd September 2025.
Order has been passed.
Ah.
Where is that? Which? Oh, you have it. One. Where? 24. Oh, this was sent to the petitioner also.
Forwarded to SP Bardhaman, Subhajyoti Shaha. Subhajyoti Shaha,
Thing I can't.
30th September 2021. Please,
N.
N. Kindly see the prayer in the way. Date what, September 2021.
Date of 125. This is the impugn order. To break the phone. His application has been rejected September 21. Year or later, it is the same payments case has been rejected. Therefore, by filing a fresh representation, and where is the application that he claims to have submitted on 14th October 21?
14th October. October तक तो October
October 21, there is no,
15th October.
there is one of 14 November. At page 44. What does it say? Does it refer to the earlier rejection?
Most probably date would be the first number 2012 in Bengali documents.
14 November 21. Or 1st November.
In November.
Refer to the earlier rejection. Refer to earlier.
Fourteenth of fourth of এখানে কোথাও 14th অক্টোবর এখানে কোথাও
What have you said? You received it? Yeah, I received this. What does it say about it? Yes.
May I seek for an adjournment for a day?
No,
But
sir.
may I see this one?
Enough is enough.
No, my lord. I have called the client today. He's present.
What
in court.
client?
But
Everything
I
is
need-
here.
But I need certain instructions.
Sir, everything is here. Argue on the merits. Yes.
So, my lord, lordship would kindly, my lord, see the order, my lord, rejecting my claim for compassionate appointment.
Yes.
So, my lord, the facts here are
Where is the rejection?
kindly comes to page 40, annexure P9.
40.
Page 40, 40.
Is the same.
May I please?
Yes, give it.
But with reference to the above, I am directed to state proposal on the above noted subject has been taken up and examined in this department in the light of the notification number 251 EMP dated 3rd December 2013. Lordship would kindly note this date.
Yes.
Of the Labour Department, read with subsequent amendments made time to time and the case records. It appears that the candidate was a minor at the time of death of the deceased employee and he did not fulfill the required conditions as laid down in notification number 251 EMP dated 3rd December 2013, read with notification number such and such dated 1st March 2016 of the Labour Department, Government of West Bengal for being eligible to be considered for appointment under exempted category. Accordingly, I am directed to state that the government regrets its inability to approve this case for appointment under exempted category in light of the guideline contained in notification 251 EMP dated such and such. Now, my lord, kindly comes to this fact that, my lord, the employee, my lord, he died my lord, his date of death
15/6/2008.
8. So, my lord, if a person, my lord, has died in 2008,
Yes.
my lord, whether his claim for compassionate appointment, my lord, can be considered, my lord, on the basis of two government circulars which have come into effect in 2013 and 2016.
All right. So this we will consider. What else?
Now, my lord, secondly is, because, my lord, these circulars, my lord, they cannot have any sort of retrospective effect.
We have understood what you are saying.
Now, my lord, kindly comes to the order of rejection by the tribunal. Now, my lord, first three
Yes.
paragraphs, my lord, lordship, my lord, that is the order impugned.
And your OA, where is your OA?
My lord, OA is,
What is the prayer in the OA? Let us see.
my lord, it starts from page 54. My lord, the facts of the case starts from page 58.
What
Paragraph
is your prayer in the OA?
prayer is to grant me compassionate appointment. Lordship would get the prayer. My lord, it starts from page 62 bottom, my lord, page 63. A mandatory order be passed and or direction be given upon the respondent authorities to forthwith cancel, resign, withdraw and or set aside the order of rejection dated 3rd September. Order to grant compassionate appointment to the petitioner and to transmit the entire records and not to give any effect or further effect to that letter. Now, the tribunal kindly comes to the order. May I place it from the 3rd paragraph of the order implemented?
You may, whatever.
From the submissions of the learned counsel and the records in this application, it is evident that after the death of Ramin Kumar Saha, the constable with West Bengal Police on 15 June 2008, the widow and the applicant's mother submitted a plain paper application dated 30th March 2012, praying for an appointment under compassionate ground for a son. It is not in dispute that at the time of death of his father, the applicant whose date of birth is recorded as 9th October 1994 was a minor of 13 years, 8 months and 6 days. The respondent authority in the impugned order relied primarily on this point that such employment cannot be offered to a legal heir who was a minor at the time of death of his father. The applicant on 14th October 2021, after attaining the age of employment, had applied himself before the respondent authorities. Having heard the submissions of the learned counsels upon considering the facts and circumstances of the case, this tribunal is of the clear opinion that the reason of being a minor relied on by the respondent authorities, rejecting the application was a correct decision. So I could not have made the application. I was born in 94. My father died in 2008. Admittedly, I was a minor. As soon as I attained the age of majority, my lord, I immediately applied.
Yes, that's all.
These are my submissions.
Yes, take down. Heard learned counsel for the petitioner and the learned state counsel. The facts which are not in dispute are that the petitioner's father died while in harness on 15/6/2008. An application thereafter, an application 4 years thereafter was made by his mother on 30/3/2012 seeking compassionate appointment in favor of the present petitioner. Stop. At the time of demise of his father, the petitioner was 13 years, 8 months and 6 days old. Even at the time of making of application by his mother, he had not attained majority since his date of birth is 9/10/1994. The petitioner's claim has thus been rejected by the authorities by an order dated 3/9/2021. Stop. The learned counsel for the petitioner submits that the order, insofar as impugned order, insofar as it places reliance on circulars of 3/12/13 and 1/3/2016 is unsustainable, the circulars having come into existence much after demise of the petitioner's father, having no retrospective operation. The petitioner, as soon as he attained majority, has again made an application. Full stop. Having considered the submissions, we find that the undisputed position being that the petitioner was ineligible for compassionate appointment on the date of demise of his father, since he was about 5 years below the age of majority. Full stop. No provision has been brought to our notice that as on the date of demise of the petitioner's father, that is 15/6/2008, there was any circular under which a minor could make an application, or that a minor was allowed to attain the age of majority before making an application. Stop. The plea of the petitioner's counsel that the two circulars of 2013 and 16 are inapplicable, therefore, is devoid of any substance. Stop. The reason assigned by the impugned order for rejecting the petitioner's claim does not require any interference, in our opinion. Full stop. We further find that a second application has been made by the petitioner on 14/10/2021. The records further reveal that an order of rejection of 3921 has been challenged by filing a application before the tribunal in 2024. Stop. By all means, the petitioner's claim is unacceptable. Full stop. The writ petition is accordingly dismissed. We find no infirmity in the order of the tribunal.
Number 10.
There are two orders. Why you have an annex 2 order?
Was there,
Huh?
application is there, and my lord, I had also preferred one miscellaneous application before the tribunal to bring on record certain informations which were supplied to me through the RTI applications. Now, my lord, I had tried to impress upon the learned tribunal that the information so given from the RTI application, it is quite apparent that since 2016, my application is pending. Now, my lord, the learned tribunal has been pleased to dismiss both the original application and also the miscellaneous application only on the very short conspectus of limitation ground. Now, the learned tribunal did not go into the...
What is that material? Show us. What is that material which you showed that it was pending?
Yes, my lord. This may kindly takes up page 59 first. It was the part of the original application. Now, it is dated 18/8/2016, from where it can be found out that my claim for compassionate appointment was resubmitted in the year 2016. Now, my lord, page 61, it starts with the MA application, which I had made before the tribunal to bring on record the RTI application. Now, my lord, the RTI application is at page 67. It starts from there. Now, my lord, page 68, in page 67, wherein the RTI application has been made, I have made reference to the forwarding of such prayer for reconsideration of my prayer for compassionate appointment, which I had just shown before your lordships of the 18/8/2016. Now, my lord, my query was page 68. What was the observation of the Joint Director of Textiles, Sericulture, North Zone, Siliguri, Darjeeling in this regard? And I have sought for it. Now, my lord, the answer was given to me at page 69. Point number 1, the application was duly forwarded to the higher authority for needful action. Now, my lord, nothing and no further information was also provided here. Now, my lord, it has not stated that my application has been dismissed or it has not been taken into consideration. Therefore, my lord, it can be presumed that it is still pending. No fruitful action has come up after following the 2016 resubmission. Now, my lord, the learned tribunal was pleased to dismiss the original application only on this ground and not going into the merits of the matter.
So what is the order of 2016 that you challenged? 112/2016?
But the rejection is at page 54. It refers to 14 double B new clause added of the 251 EMP.
So this is subsequent to this page 59.
Why not?
That page 59 contains some noting, file noting that cannot be looked into first of all. Even
but
if we
it
look into it, that is of August 2016.
My lord, but it was after the
4 months thereafter, the claim has been rejected, and this is a communication.
My lord,
So
that-
therefore, that is now irrelevant.
Now, my lord, I say this.
Page 59 is not relevant anymore.
My lord, this is the 1st of December 2016. My lord, kindly see,
Correct.
this is 1st December.
That's what we are saying. You rely on page 59 to say that it was pending. Page 59 is a file noting which does not create any right in your favor.
It's
Of-
having a memo number also.
Of August 2016. So this is prior to rejection. Thereafter, it has been rejected in December. Therefore, 59 is not relevant now.
Yes, that is true. my
So
lord.
therefore, the December order was required to be assailed by you. Why you have not assailed it?
Yes, the December order, the 1st December 2016's order, that has rightly been, my lord, kindly sees page 29. That is the relief which I had sought for before the tribunal. That has been challenged there too.
Correct.
Clearly.
That is what we are saying.
My lord. So I had,
Why after 8 years? That is the point.
yes, my lord. Therefore, my lord, I had specifically stated in
Where
the,
is it? Show us.
in the
Show us
limitation,
from your OA what you have said. Why you are approaching
Yes,
after
but-
8 years?
but at page 22, I have stated in the limitation, under the paragraph limitation, but I have clearly stated that I am being aggrieved since the appointment has not been given to me, and it is therefore a continuous cause of action.
So even 1 day prior to retirement, you attaining the age of retirement, then you can file.
No, my lord, there the
Why not?
statutory-
It continues till that date.
No, my lord, the statutory limitation would come.
Is this
that
limitation is there under the act?
Yes.
You
No,
can-
my lord, and my lord, I have got one decision to show before your
Yes.
lordship.
Show us.
It goes on to show
Yes.
that I need not prefer a separate application for.
Who is saying separate application? We are not asking you to give a separate application. We are asking you to show from the OA what you have said about the delay.
Yes, but this is it that. it
This
is
is
a-
all you have said. That is a continuing cause of action. Yes, we are not on that. We are not asking you why you have not filed an application. You can give it. We will look into it, but we are not on that.
I would also like,
Yes.
my lord, from that decision itself. From that decision itself. WPST 67 of 205. My lord, two issues,
Just a minute.
my lord. My lord, my humble prayer would be this, my lord, that since the tribunal has been too technical in rejecting my prayer and it has not gone into the merits of the matter, my lord, but I'll be praying, my lord, let the tribunal hear out my matter, my lord, on merits. My lord, it has not done so. It has gone only on to the.
What is that fresh consideration referred to in para 2 of your OA? You are referring to that memo that you have just shown us, page 59.
Page 59, my lord.
All right, that's all.
Page 59, my lord. That is there, my lord. The authorities had resubmitted and asked for reconsideration of the same, my lord. And my lord, the tribunal.
This is of August 2016. Irritating submission. 2016 and the rejection is of December 20. Same difference. The thing is 4 months after this. Prior to this, so therefore there is nothing pending after this. So what was pending after the rejection that we are asking you?
After the 1st December
2016, what was pending? Again, we are asking you.
I have challenged the rejection in 2016's order. That I have challenged, my lord.
In paragraph 2 of your OA, you have said that there is consideration afresh. Where is that fresh consideration after December 2016? Which document you have brought on record which is after December 2016?
This exercise is complete. My lord, may kindly see is page 53.
Yes.
There, the reference has been given that resubmission of prayer of Sri Deepak Rai Chaudhuri, son of late Shapon Rai Chaudhuri, ex-assistant, Matigara Sericulture.
So this is a resubmission, all right. This is a resubmission made by you. It has been forwarded. There's nothing.
Then at page 58, Lordship, it's written in Bengali, but the stamp has been given. Not very clear.
Whatever it is.
22nd, something is there, my lord.
So making representation after rejection, one after the other. That is obvious.
But my lord, let the matter be, my lord, be remanded.
All right, heard learned counsel for the petitioner and the
beg to appear for the petitioner manual in item number 12.
Just let us read.
Yes.
Yes.
Yes. If your lordship kindly recollect the order in passed by your lordship just now, item number 9, that was dismissed on the for compassionate appointment also. In my case is akin to that, but with a slight difference. My lord, I have 3 things to submit. The petitioner was 12 years of age when his mother was died, and his father applied
No,
for
he
the
was 13
compassionate.
years. He was not 12 years.
13 years of age. I beg apology, my lord.
Yes.
13 years of age.
Don't mention a wrong fact.
My lord, I beg apology.
Yes.
His father applied for compassionate appointment of his son, and that is within 6 months of the date of death of the mother of the petitioner.
Yes.
My lord, I have searched, but at that relevant point of time, there was no notification regarding prescribing any time limit for submission of any representation for compassionate appointment. In December 2013, first time there was a notification that prescribed a time limit for representation to consider a compassionate appointment. So, in my case, there is no restriction, even though that is taken into account. The petitioner's father applied for within 6 months from the date of death. Secondly, my lord, the petitioner applied on getting majority for compassionate appointment. My lord, it is not the case of the authority that I am not entitled for compassionate appointment. The order of rejection that has come from the authority, they have cited 2 clauses of those notification, one of 2013 and one of 2016. Their only contention is that the application was not made within the prescribed time limit. My father applied for within 6 months in his on March 2013, and those clauses that has been cited by the authority at page number 25 of my application is not applicable to me. And if that is considered of 2013 representation, I am entitled for compassionate appointment of the death of my mother. First, secondly, my lord, there is a judgment that has come from the Honorable Reed Court, single bench of this Honorable Court, but the Honorable Court has observed that even if 1 day prior to retirement, one employee dies, the words can apply for compassionate appointment. That is also annexed here too at page number
How is that relevant in your
26.
case? That's not your case.
My lord,
If
my case is
such
that I
issue
was
does
minor.
not arise in your case, then why are you referring to a judgment? Who says
Man,
that
I
you have
am
applied one day prior to your retirement, therefore it is not being accepted? Who has said?
No, no. My lord, the case is that I was minor and
So
my
therefore,
father.
you are a minor, and whether there is, even if there is no time limit, can you be allowed to wait for 10 years to file
No,
an
my lord.
application?
Within 6 months, my father applied. That
So
may be
at
considered, my lord.
that time, so either you have to say that you have applied within time,
Yes,
then your eligibility has to be considered. So
my
were you
lord.
eligible under which circular you were eligible being 13 years old? Tell us.
No, my lord. I was not eligible. That's why my father was applied. My father
Therefore,
applied for the post.
for
And
you,
on getting,
he had not
for
applied for
me,
himself. Yes.
no, my lord, for me. And on
Yes.
getting majority after 5 years, I applied.
Very well.
But the case of the authority that I within the prescribed time limit, I did not apply.
Where is
But
the
I was
rejection order?
minor.
Where is the
My
rejection order?
page number 25.
No, he was a minor. They have said, what are you saying? Don't say that.
No, my lord.
Please
At
read
the
it, sir.
yes, sir. This
Yes.
is to inform you that the prayer of Kamal Halar, son of late Raimoni Soren, ex-staff nurse, is not eligible for employment on compassionate ground in terms of clause 6 CC of Labor Department, notification number 251 EMP dated 3/12/2013, read with clause 10A of 26 EMP dated 1/3/2016. Because the applicant was minor, nearly 12 years, 2 months old at the time of
Correct.
death of the ex-employee.
Don't say
But
that it is a
your
case
lordship,
of delay. They don't
no, my
say it
lord,
is a
but
case of delay. They say it
no,
is
my
a
lord,
case
but
of ineligibility. You are saying
my
as if
lord,
they have only rejected because you didn't file within time. But that the
my
order
lord,
reads otherwise, contrary to your submission.
my lord, if your lordship kindly see the notification, only the
First,
time
sir,
limit is
let us
mentioned.
be clear on facts. You are making submissions which are contrary to the impugned order. Therefore, we asked you to read. That's not the ground of rejection that it was not filed within time. The ground of rejection is ineligibility.
But subject to correction, my lord,
Subject to correction.
the clause they have referred, that is only the time limit. If your lordship kindly see the notification, the clauses that they have referred,
Whatever
that
it
is only
is, whatever it is, that wrong quoting of a provision will not invalidate the order. The law is quite settled in this regard. Either you are eligible or not eligible. You know you are not eligible. 12 years person cannot be. You may have taken the same ground that 13 and 16 was not applicable at that time. Even if it was not applicable and there was no time limit. What does that mean? Your eligibility, you have to be eligible, and compassionate appointment concept is very clear. Immediate succor to the family who was left in penury by the death of the breeder.
yes.
So therefore, others are also in line. You know that there is a limited number of seats for compassionate appointment. So the more deserving person has to get it. The less deserving, they will not get it. That is an unfortunate circumstance. Which scheme was applicable at the time of death of your father?
At the date of my mother, there was actually I have
Mother,
found no
yes.
scheme. Mother, I have found no scheme for the first time.
Found no scheme.
2013. No, I have searched it out. I'm in 2013 probably because before that they are guided by some other circulars that I have not found.
So therefore, the earlier circulars will govern. Don't say there was none because you could not find. We have a compilation of circulars from 2000 and you are saying there is no circular.
That the learned advocate for the state may submit because I don't have the copy also.
You say you could not find anything. It is all there in the compilation. You say you could not find anything. Very Yes, what is this clause 6CC relied upon? That is 2013 EMP 251. Six CC is regarding minimum age. It is not regarding delay. Shall invariably attain the minimum age of recruitment within 6 months from the date of death. So this 6 months was subsequently made 2 years. When in 2016? 16. And what was the time limit back then when the mother, at the time of death of his mother? No, he was over age. He was 43 years. How can he apply? 22/9/2012, which one was applicable? What is the date of this? 2008. So at that time it was 6 months. So there is no change. 6CC has remained the same. It is the same. There is no change.
My lord, ma'am. As your lordship may think.
2008 also it is within 6 months. So the 13 circular has merely reiterated the same provision that it has to be made within 3 months, 6 months. In 16 it has been further enlarged by 2 years, and thereafter there is also provision which says it can be extended up to 5 years in a special case by a particular authority. Yes, so therefore there is no provision under which it can be granted. The petitioner's mother
I'm grateful, ma'am.
Lord, 13, my lord, I am for the petitioner, my lord. My lord, in this matter, my lord, there was a dispute regarding obtaining no objection from the erstwhile advocate. Petitioner has affirmed an affidavit, my lord. He has written to the erstwhile advocate. The letter has come back as left. My lord, he is not picking up calls, my lord.
Just see what he has written in the letter.
I have seen them. The language is not very proper, my lord. I know.
Well, he is also your friend.
Difficulty is, my lord, I knew him personally, Mr. Moitro. My lord, he doesn't come to court any further.
He doesn't
Come to court any further.
He doesn't come anymore.
And he is not contactable, my lord. No one knows where he is.
But see, he is the petitioner is a medical officer.
Well, I have seen, my lord.
He uses such language for a lawyer. What do you expect?
I've seen that one.
Have some grace.
The language ought to have been different, my lord.
And after all, this letter he is writing to your friend only. He is dismissing him as if he is his employer. Basic decency and courtesy is required. That would, yeah. The question is to be known. Every time I input it is taken up, I forget. System and show me. So, one matter of similar kind was taken up when I was sitting with His Lordship Justice Tandon. There is some provision in the appellate side rules for withdrawing the power from a lawyer by making an application.
File an affidavit, my lord. If make a
Which is that provision?
That's rule 72 in the appellate side.
72. Can you please give us the provision so that we know? His Lordship had showed me, but I don't remember. In the court.
As far as I remember, 72.
72. So if there is a procedure prescribed, it is better that we go by the procedure. We don't know, maybe we don't know what is the reason.
The matter was dismissed for default. The matter was actually dismissed. Now the restoration has been filed.
That we understand, but a review and restoration is either to be carried out by the same council or after no objection from the council. That is a settled law. So therefore, No, but he is not. He is filing an affidavit that he refuses to come. He says, I cannot come. That is there, but if there is a procedure prescribed, then it is better to follow that procedure. We don't know in which.
Five, my lord, to Rule 72.
Chapter 5, Rule 72. So application has to be filed. You file it. What is the big deal? 1 or 2 days you file it. Take it up. You mention after it is filed.
Difficulties, but in the application, one advocate has to affirm it. I mean, to identify the client. So the new advocate record may.
See what it says. A party desiring to cancel the wakalatnama filed by him in any appeal must file. That party must file a duly stamped and verified application for the orders of the court. So he has to file the application for the orders of the court to cancel the wakalatnama. This he can do. If the earlier counsel is willing, then he has to sign. Otherwise, he will do it. So he will do it. File it and you mention it. We will take it up. The learned counsel, Mr. So-and-so appears and submits that the erstwhile counsel who was dealing with the matter on the date of dismissal of the matter for default is not responding to the communications of the
due to some medical emergency, she left the court. So I'm praying for a 2-day accommodation.
2 days.
Fine.
On account of some personal difficulty, we are informed that the learned counsel for the petitioner had to leave the court emergently to stop lists in the next week.
Item 15.
But I am for them. Mala. According to your lordship's order, Lord, all procedure has completed. Your lordship file direct to file The affidavit, they have filed affidavit, I have taken exception. It is covered by your lordship's judgment previously in my another petition. Here your lordship will find they did not call for medical test as they have failed physical efficiency test. Therefore, your lordship has already been passed an order, but I have annexed it. In my exception, your lordship totally covered by this. If your lordship kindly see, now there are 8 petitioners. Out of 8, 2 has already been given appointment.
2 have been given.
2 have been given.
Which 2?
2 means your lordship will find that affidavit on behalf of the respondent. They have given that.
Which 2? 4 and 6.
Means 4 and 6.
4 and 6 have been given.
Given appointment.
So 1 to 3. 1 to 3, 5 and 7. 5 to 8. No, 5, 7 and 8.
They did not qualify the PET examination. Therefore, they did not call for the medical. Your lordship's judgment is here.
1 and 2 PET. Then 3
non-metric.
non-metric.
Yes.
Yes. And what about 5 and 7? 5, 7 and 8?
Not called for overage.
7 and 8 overage.
Overage. Right, that is also judgment.
And
covered.
5?
Non-metric.
So 5 and 3 are same.
Yes. Your lordship can pass the order. I have annexed the judgment of your lordships in my exception. Lordship will find.
There is a rejection of the claim. Is
rejection, they did not call for. Therefore, your lordship passed this order. Your lordship kindly see page 9 of my exception.
9 of?
Of my exception filed by the district.
Okay.
I have annexed your lordship judgment totally cover exceptions.
Why do you club so many category of persons in one petition?
Your lordship can dispose of 2. Paid and overage.
Is it permissible to combine or different kind of prayers in one writ petition?
Your lordship has
One is seeking a relief of pet, one is seeking relief of overage.
At that time, they did not take in that step. They did not call for any. Therefore, that was fine.
During pendency of the writ?
Yes. This is the order.
Pendency of the proceeding here or pendency of the proceeding before the
Proceeding here.
Here.
Proceeding here. By direction of the another coordinate page, then they have taken. And your lordship kindly see your lordship judgment below. I have annexed. My exception.
So pet is covered by judgment.
Yes.
And
overage is also covered by your lordship judgment by single judge.
So that means 1, 2, 7 and 8.
That means 1, 2, 7 and 8. Yes.
And under which order it was considered? Which is the earlier order under which the issue was?
I have
Give us the date. Tell us what is the date.
Date is 26 March 2025.
24. 26 March 25.
Order 5.
No. Under which order passed in this proceeding they were directed to consider, whereafter they have considered.
That order I have. The previous order of Honorable Justice.
Yes, it is of 18 September 23. Where is the rejection order? Where is the rejection order?
Rejection order, they did not give, only they have annex here. In the,
In which, where have they annexed?
their affidavit, behalf of the respondent by an order passed by this court on 23rd March, 24th March 2025. That affidavit was affirmed on was affirmed on 17th April 25. They have annexed the part. Annexure.
Students. Where are the judgments? Where are the earlier orders? You have, in where, in which?
That I have had exception to be taken of the petitioner, affirm on
17/4.
15th of March, 15th of May 2025. This affidavit. I have given copies to them also. That file. Exception taken by the petitioner in respect of
15/5.
15/5, yes, 15 May.
There is no. Is not on record.
But I have filed.
When did you file it?
And three affidavit I have filed.
But 15/5 one is not there. There is one of April, but there is no affidavit of May.
Accident, that is a particular that.
This is the only exception. It is the same. Just see if it is the same. You see for yourself. That is the only one. There is no exception of May. So therefore, we are asking when have you filed it?
I have access.
Huh?
কথা আছে না তো? দিতে পারবেন?
Already passed. That's the case also. There was someone was being disqualified in fact. Was someone said to be over it. We direct the respondent should conduct a medical test without raising objection regarding that and Ah. No. What is yours? Second one. Page 12. What is the age?
Regarding age particular, age is within 56 or 50. They have up to 58, they have given appointment. I have annexed it.
Yes, we have seen that.
That's what they are.
Maybe. What is the retirement age? What is the retirement age in railway service?
Age.
Retirement age in railway service, what is it?
Railway service, there is a three kinds of retirement. 140 years, another 55, scheduled caste more than 50, more than 45.
45 is the retirement age?
No, retirement age is 60.
Between for 4 years. Bye. Where is the learned advocate?
Last week he was standing outside of court.
Yes.
Their lordship passed it over, not today, then he will leave. Okay, he will not come. Previously, junior has taken time. Add to that, that junior has also taken time. Therefore, nobody has come today.
Who is the advocate on record is also not here.
Therefore, they have not come today.
Advocate on record. Ask him to be here at 2 p.m. Ask him to come at 2 p.m.
Trying to be.
PM call this.
Just go through that.
Sixteen, madam, I'm late by
I
Mr.
appear for the applicant, my lord. If your lordship, my lord, takes it up at 3 PM subject to convenience, I will reach there, my lord. It has to be done, my lord, through, I have to be personally present, subject to kind convenience.
Come tomorrow. Not today.
Tomorrow, my lord, I have a difficulty, my lord. The lordship day after tomorrow.
All right, if you have a difficulty, ask someone to make a mention tomorrow, not today.
17.
I appear for the petition.
Your lordship,
Being single member's decision, that is over.
That is all.
Let us see on merits what it is.
What point involved, my lord? After retirement, he has moved before the authority for interest on the, my lord, benefit because at that point of time disciplinary proceeding was going on.
What was going on?
Disciplinary proceeding. That is why, my lord.
Disciplinary proceeding, when did it end?
Yes, I tell you, lordship.
So rule 10, you are relying on rule 10.
No, my lord, your lordship kindly peruse.
Railway pension rules.
This is the case, my lord. A disciplinary proceeding was initiated, was found guilty, but on humanitarian ground he was allowed to, no punishment was awarded because by that time he retired. He retired 2016.
What is the date, please?
Retired on 30th June 2016.
And the proceedings, when did it?
Proceedings ended on, my lord. 165. Yes. No, 161. Due to order, 23rd May 2019. Page, my lord, 161. Uh, 165. No, the last order attached. Aki date ki? Last year order 2023 तो 2022 এর একটা order আছে page 168 last order your lordship will get it at page starts at page 166 and ends at page 168. That is, my lord, dated 14 July
2022. This is practically the discretion of the court whether in the facts of the case or not the proceeding was delayed to be his fault or the fault of the authority. Main order 166. Salary payment rate is low 9th July 2000. যেহেতু ক্ষমা করেছে আবার কেন?
So his gratuity has been paid now.
Everything paid.
Only interest is remaining.
Only this not there is no rule is involved. Only discretion of the court is the facts of the case whether he is entitled. When the Supreme Court has said, man, when there is a delay due to the action of the charged officer, they are not entitled. But when the delay occurred on the part of the authority, entitled. They,
So this speaking order was assailed by the charged official. In the OA.
In the OA. Ordering portion alert, internal page, serial number, paragraph 3.7 is the finding part. Internal page 3 of the order. Thereafter, it found that 94,564 being leave salary was released. The applicant on July 2019. The commuted value of the pension amounting to rupees 14 lakhs and odd was released to the applicant on 9th July 2019. And gratuity amount of rupees 11 lakhs was released to him on 9th July 2019. The applicant has filed the way to the claim interest of the aforesaid dues.
So now the order has been upheld. The order of 23,519 has been upheld. But at the same time, interest has been awarded by the tribunal.
I have only one judgment of the Honorable Supreme Court where the Supreme Court has said if it is fault on the part of the no other intricate point is involved in this.
Yes, what have you to say? The order has been upheld by the tribunal. Yes, but that has now been affirmed by the tribunal. Yes. Page 161, are we referring to the same order? If you can refer to 161, please. Yes.
They're not asking penny, please decide it. Any charges will improve, we drop. The charges are dropped.
Guilty and charges drop both in the same breath. Yes. The intention of the order is clear. Having found you guilty, they say that all his dues are pending, therefore we are not proceeding any
Making me in a situation where I cannot even say that what I could not fix my case or my defense is in one hand, and on the other hand, we say that I'm a
No, therefore, but you have challenged, but you have challenged that order, but now it has attained finality. Insofar as you are concerned, the order has now become final for you. Only allowed the interest, therefore you have chosen not to question the order now. So where has the tribunal set aside this order? So therefore, this order is affirmed in specific terms by the tribunal's order. Affirmation of the order is accepted by you, but only on the condition that it has allowed interest. So therefore, whether interest is to be allowed in such a case, you have not participated in the proceedings. That is now true because the order is accepted by you. Now again, let us see, the tribunal has set aside the order. Then you repeatedly say, I have challenged, therefore we are asking you. Now it is affirmed insofar as you are concerned, there is no, it does not lie in your mouth to say that the order is under challenge. You have accepted the finding only on the ground that the interest has been awarded. That is all. Yes. You do not dispute the finding in the order. Now therefore we are saying, we are looking at it now, we are not the tribunal. Yes. Let us see this finding in the tribunal's order that since charges are dropped, we do not proceed any further. Let us see this finding where it says that since charges have been dropped. (164). What is this 164? And this is the final order. Final order passed by the tribunal. Impugned order. No, it is an order prior to the impugned order.
Yes. Where is the representation disposal speaking order? No. It's from 16 is 167. April 17 means 5 months. Then thereafter, they have sent for guidelines.
Yes, so what do you want to show from this order?
I said that this particular and I said that some charges have come. That even I do not have mechanism or please my so whatever the benefits that I have got for this purpose.
Paragraph 9. Yes, 9 actually. 8 there is no decision.
Proceeding charges charge particular drop only if the same are not established. It is also inquiry for that therefore from proceeding to get. Instead, the charges were dropped, communicated from since the charge official had retired on certain circuit, determined the ST 20 and moreover, that uncharged is established. He subsequent he should have said something. So, however, since as long as the activities depended on
Yes, some judgment you are showing.
Other demand I have given.
You have given us.
Correction I given. I cannot give. Only you will take up this. On his prayer, it was adjourned. I showed this judgment. Only you in any event, you will to take my judgment. Or not? Yeah. Six to seven.
So here the interest has been awarded.
But what was the finding? Finding is, my lord, when is to be awarded.
Yes.
There was a dispute between the between the department, but the Supreme Court.
Who was liable for delay? That was an issue to be
That
seen.
was- Here the clear. my
Here
lord,
there
he
is no,
challenged- he
here,
challenged-
here there is no dispute now.
Yes.
Because you say that you have accepted everything, but you will not pay the interest. That is all. You
And-
don't say that he is
And he
guilty.
also challenged the speaking order that was not interfered with.
The speaking order was also challenged.
Your lordship will get from the front, initial portion of the order sheet of the impugned order. What was the subsequent?
This order that you have just read of at page 166 was challenged in the OA.
Your lordship will get it, the impugned order, second page, in internal page 2. Prior is set out.
That was not quashed.
No.
So even if it is not quashed, let us take it. Then how this order justifies depriving him of the interest? Let us see this order. Interest for 3 years.
Lord, contempt proceeding, your lordship sometime allow the contempt, my lord, scot free, scot free, my lord, without by giving, my lord, in the facts of the present case.
Order is very unique. Therefore, it is posing a very unique question. What is the purport of the order? When charges are dropped, then he must get everything. Nothing which remains.
He has got everything, my lord. He has got everything, but the delay was only due to the.
Right, we'll pass the order after this. We'll come back up.
Has been cited subject to correction in the order sheet itself. This internal page 4.
Later. This is not the time for mentioning. Mention in the morning. Yes. Para 13 and 14. You are relying upon para 13 and 14.
These are different point.
Huh?
A different point.
This is delayed payment. Delayed payment will carry anyway because you have taken a humanitarian view. Let it be humanitarian. Yes, take. Or learn it. Yes.
Kindly record it.
Yes, yes, yes. Which judgment you have given us?
2024. 4SC.
Yes, all right. No, we'll record your submission. That delay is on his part. Don't please. Learned counsel for the petitioner as well as the learned advocate representing the respondent stroke applicant. The petitioner, the applicant was proceeded against in a duly constituted departmental proceedings. Full stop. He attained the age of superannuation on 30/6/2016. Stop. About 3 years thereafter, a speaking order has been passed in the proceedings. Full stop. The speaking order takes note of the fact that in spite of best efforts, the proceedings could not be concluded. And therefore, the order which has been passed by the disciplinary authority reads, take it from page 161, P9. On the side I have marked. This order was put to challenge by the petitioner before the Central Administrative Tribunal within bracket CAT for short in OA number 1373 of 2022. The tribunal during pendency of the proceedings directed no, as Cardo tribunal in view of the stand taken by the the petitioner before the tribunal also prayed for grant of interest on the delayed payment of gratuity as a result of the speaking order dated 23/5/2019. In order to verify as to responsibility for the delay, the tribunal directed the authorities to pass a reasoned and speaking order on this issue, which came to be passed by the authority on 19/7/22. The speaking order holds the petitioner liable for delay in the proceedings. Stop. This order was also assailed by the petitioner in the OA. Full stop. The OA has been disposed of by the tribunal in the following terms, paragraph 9 and 10 of the CAT order. This order of the tribunal is assailed by the Union of India in the present proceedings. The learned advocate appearing for the respondents, for the petitioner submits that from a bare perusal of the order passed by the disciplinary authority on 23/5/19, it is more than obvious that the issue has been given a quietus in taking note of the inordinate delay in concluding the trial, delay being attributable to the applicant. Stop. This finding was reiterated by the authorities in the reasoned and speaking order dated 9/7/22 passed pursuant to the tribunal's interim directions. Since the petitioner is liable for delay, he would not be entitled to any interest on the gratuity which remained withheld during pendency of the disciplinary proceedings. Only if the delay was on account of no fault of the petitioner, the applicant, he would be in a position to claim any interest. Would stop. The facts being different in the present case, the claim for interest is unsustainable. The learned advocate representing the respondent, on the other hand, relies on a decision of the apex court in the case of SK Dua versus the state of Haryana and others, reported in 2008-3 SCC, page 44. तो पिटिशनर वाला में जजमेंट का साइटेशन बताया 2022 4 SCC 627 नहीं, क्या लास्ट पैराग्राफ उसमें पिटिशनर का पढ़ो
Whether diaries.
Lordship, in item number 18, I beg to appear for the petitioner.
Item number 15.
Lordship, in item number 15, Lordship, the assisting counsel for the respondent has requested me to seek for some time. She is suffering from fever. She is having the entire documents with her. So
we have to send an
without the-
invitation. We have to send an invitation. If she has instructed you, should have been here when the matter was called on ground of illness. This is
Lordship, I
how
was
you are
engaged in,
honoring her request.
Another phone.
She is ill, let her be
Lordship,
here.
I was
When? Tomorrow?
Lordship, it kindly takes up the matter on Monday. My lord, kindly fix a time, Lordship. She will be there and
in spite of adjournments being granted earlier and our reluctance to grant another adjournment, we have acceded to the request of Mr. So-and-so, who has appeared virtually, in view of the submission that the learned advocate who holds the brief is unwell. Stop. By way of last indulgence, the matter is adjourned to be taken up on give the date of Monday.
if time can be fixed, Lordship.
No, come on Monday. It will be at the top.
Grateful.
Item number 18.
Lordship, I beg to appear for the petitioner in this matter. My lord, it is a land use matter. The candidature of the petitioner has been rejected. My lord, the last order passed by your lordship in this matter was 28th of January 2025. And after that, my lord, they have on regular basis taking adjournments in the matter. And nobody is appearing in this matter.
Last day, there was an appearance on behalf of the railway, and you are saying nobody is appearing.
My lord, appearing but taking adjournment. Someone
For
else is
what?
coming and taking adjournment.
What is the last order?
My lord, last order lists the matter on the 8th of April. The matter got adjourned with a similar item. Last order, no, 9th of May, the last order.
9th
My
of
lord,
May is the last
regularly-
order.
14th of May.
Without
14th of May.
verifying anything, you just start making submissions.
Apology, your lordship. No,
You
my lord,
should,
actually,
you should apologize. This is not the way. What do you think? In haste, you will get an order of some kind.
no, your lordship, but
That appears to be
regularly
the
they are taking
impression that you
adjournment.
convey. You read the last order, what it says. Nobody is appearing,
learned
repeated adjournment. Anything you want
Well-
to say, you will just say.
But my lord, whenever they are, I'm apologizing, my lord, but the matter is that whenever they have
This is
appeared
not
after the month
appreciated
of
at all.
January,
This is not expected and not appreciated, both. There is a direction for filing an affidavit on the last day, and you are
Yeah.
saying nobody is appearing.
my lord, the last order
Read the
passed
last
by your
order, sir.
lord,
Read the last order. What, my lord?
let him place the same on record by filing
Yes.
an affidavit by
Yes.
Monday next on 9th of May.
So
But my
therefore,
lord,
there is no
they have not-
appearance. And they are
that-
taking adjournment simpliciter. Anything you will suggest or submit, contrary to records. In spite of the last order dated 14/5/25 for placing on record an affidavit, comma, there is no appearance on behalf of the respondent. Stop. For enabling his appearance, By way of last indulgence, the matter is adjourned 1 week.
Gratefully, Your Lordships.
Lordship, I'm appearing on behalf of the petitioner. Your Lordship, on the last occasion, Your Lordship was pleased to direct us to file a supplementary affidavit. Your Lordship, has not. If we are affirming it, we are getting it affirmed today. Your Lordship, the officer who was to affirm the affidavit, he was out of town. So I'm praying for a day's adjournment. Your Lordship.
All right. Not today. Let them file tomorrow. We'll see. Ask someone just to receive it on your behalf. Yes.
Lordship, item 19 to 22 are all analogous, identical.
Up to 22.
Yes.
All.
My lord, I am appearing for the petitioner in this matter. My lord, last order was to file an affidavit with regard to their submissions.
Yes, on account of bereavement in the learned council, in the family of the learned council, representing the respondent, comma, he submits that he has not been able to carry out the last order, comma, and assures the court that the affidavit will be filed tomorrow. Full stop. Matter stands adjourned for the next week. Give the same date as the other case. In the meantime, if the petitioner wants to file any reply, it will be open to him to file. Yes, yes, you carry it with you. You keep it with you.
24. But the petitioner in this matter, my lord, Mr. Parthosati Bhattacharya, my lord, is leading me in this matter. On the last day, my lord, considering, my lord, that the common order has been challenged, my lord, by, my lord, several petitions. My lord, by the order impugned, 25 original applications were disposed of. My lord was pleased to direct, my lord, me to, my lord, hand over the list of the other cases which are pending, my lord, the writ petitions against the common order. And, my lord, the matter is to be listed together. But I have given the list, but it appears from the list that only this matter is appearing in the list. I provided the list, my lord, on the very next day. But those are not appearing in the list, my lord. No. মামলা হচ্ছে না।
You have a copy of that list?
Yes, my lord. Even before few days also we have given another list.
Who did you give it to?
My lord.
Where did you give it?
My lord, before the court officer, my lord. This was given on the very next day of the order by myself. Before few days, my colleague has also given a note list, my lord.
State along with the other matters tomorrow. Get the files. It will come tomorrow with the files.
My lord is fixing any date.
Tomorrow it will come with the other.
Very well. 25.
Lordship, kindly allow me to argue virtually in
Yes,
item
yes.
number 25.
Yes, there
I
is
am going to
none,
respond.
there is none to represent the petitioner again. We are,
Yes, Mr. Sanyal perhaps appearing for the petitioner.
no, since the last day he has not been appearing. We have posed a query. After that query, nobody is appearing.
Yes, because Lordship, that issue are still there on the self-same issue, consecutive read applications. Perhaps that's why he is not coming.
Yes.
Petitioner, my learned senior, Colonel Babu, is busy in another court. Court number 11. He is busy in court number 11 in another matter. So I prefer not today.
All right. Not,
Lordship, kindly record my presence.
yes, as paid by the learned counsel for the petitioner, matter stands adjourned for the day.
Twenty-six.
Wait, please, Your Lordship. Lordship, in this matter, my lord, I am being led by Mr. Ujjwal Rai, my lord. The respondent pursuant to order of the Your Lordship, my lord, he is supposed to file an opposition, my lord, but which has not yet been filed.
Miss Sina is not here, Your Lordship. I am not having the instruction, Your Lordship. Deeply obliged, Your
Wait for
Lordship.
that.
Twenty-seven. Twenty-eight. Yeah, my lord, the state was to bring the records, my lord. This is regarding compassionate appointment. No, to bring the records. Lordship wanted to know what was the fate of the mother's application. It was not considered thereafter the son applied. Yes, my lord.
In the meantime, the son also applied.
His mother fell sick and thereafter the mother also expired. So the son's application has been rejected on the ground that the son was a minor at the time of the death.
Yes.
He's on legs. Court number 1.
রেকর্ডটা এখন আসে রেকর্ড Just kindly give me 2 days time and kind of recording is only for yesterday.
Record is here. Have you received the records in terms of the court's order?
I have not received any court recording of actually receive your loss.
You have not.
The time your loss. We consider one aspect things or I take care.
Well, let it be peremptory, my lord. Twice lordship has already extended it.
Without records, should we proceed?
That is the difficulty.
Should we proceed without the records? Why do you have to say something on everything? Let him come, it will only be in your interest. Yes. As prayed by the learned counsel for the state.
But this memorandum operates prospectively, subject to this cutoff date of 1/4/2010. But then the moment you certify, it has to be, or we don't know.
Is he the authority? He cannot be the authority.
Who is the person? Who is the
Welcome back.
The petitioner is taking
But item number 31, I am for the petitioner in this matter, my lord.
Who is for the respondent?
My lord, kindly accommodate 7 days time, my lord.
As prayed, 1 week.
8 July.
Grateful, my lord.
I'm for the respondent in this matter, Lord.
32, I am paying for a 1 week's adjournment, my lord.
Last yesterday,
They are good.
Yes,
yesterday you argued and produced the book, and Lordship directed to produce the book.
My lord, I have been instructed as the advocate on record is not well, so that's why.
Disability, this book.
as prayed, list after 4 weeks. Interested in it.
After argument so much yesterday that the categorization.
When the matter will come? 4 weeks. After 4 weeks.
They are not interested. What is to be done? So much vociferous argument made yesterday. Today they are required to show a rule. Now he has fallen in. Let it come after 4 weeks. Yes, let us 4 weeks.
I am saying another matter also.
No, not this way. Sorry. Yes, call the next case.
33.
This is the land wizard case, my lord. Kindly see, hearing was concluded. Kindly see, my lord, order dated 27 February 2025.
March, 27 March.
No, it's a 20 February.
Your Lordship directed to take instruction, my lord. I have got the instruction, my lord. If your Lordship can me leave, I can file by way of affidavit, or your Lordship allow me.
What is your instruction? Tell us.
Similar order was passed before your lordship in favor of the petitioner, my lord.
Some point, my lord, we have taken, my lord.
What is your instruction?
They have a copy.
You are calling him for medical.
না কোর্টকে দিচ্ছি তো
এই আমাদেরকে একটা কপি দিন।
কপি দিয়ে দিয়েছি।
দিয়েছে না না
কপি সাফ তোমার কানেক্ট কোন শুনলে
দিয়ে দিন।
You can give the hands. This.
কিসের ইনস্ট্রাকশন আছে এখন?
Yes. Want to see this. You call him for medical, then nothing is to be done. Every case you are doing it. Why a order is required to be passed for every individual? We don't know.
Land loser category, my lord. A similar order passed before your lordships in the another cases, my lord. Appointment of the land loser under the land loser policy and the respondent is settled has been recorded in the order passed on the date of proceeding, my lord. এই তো order হয়েই আছে তো, আর কেন ইয়ে করছে? এই যে দাদা
বলছিল না যে ল্যান্ড গ্রাউন্ড নাকি ফিক্সড আছে 3 তারিখে।
only blood second.
বসুন বসুন, আপনি চুপ করে বসুন।
other matter also not fixed on third. Only, my lord, only.
It is a pointless exercise. You are
In view of the.
what Supreme Court, everything is considered in WPCT 88.
Yes.
WPCT 88/23 has considered everything.
In case of your lord.
What is WPCT 88 of 23? All these things have been considered. Order passed, complied.
Yes.
Now again Supreme Court. This is discriminatory. This is discriminatory. Supreme Court order is not after WPCT 23.
Yes, that part, my lord.
It is prior to WPCT 23. Everything considered in WPCT 23.
Your lordship allow me to for this matter. One day, my lord, on third or something.
No, my lord. No.
I follow it, sir. We can take a chance, my lord. All the matters, 10,000 matter is pending, my lord, in every year. So it is necessary the policy matter, my lord. Your lordship kindly consider that part.
No, unnecessary. Necessary
Harassment, na.
You are making a plea, but your officers are not acting according to such
Yes.
concern that you are showing. In whoever case they want, they are doing it. In whoever case they don't want, they are not doing it. This we will not permit. You cannot comply with the order in one case and in the other case you will resist. Same thing which has been already rejected by the court. Where is the order passed in WPCT 88?
Page 119.
What is the date?
11/5/2023.
11/5/2023. Then what Supreme Court order? Page 119.
Still, what is the name? Relying upon the judgment or something. ভাই তোমাদের পিটিশন আমার না গজরা গল 2011 19 ওটা কত হচ্ছে 2019 19 কত তোমার এরপরে
So, from there, right? Sorry. And second part. Clarified here. And different. Let us see which is. I was this the copy টা আমাদের কপি দিলাম তো দুটো এটা দিয়ে দাও।
এটাই তো
Well, at the time of the coordinate bench, at the judgment was passed to considering the judgment of 2001 of Supreme Court. But page 19 only. But date was 11 May 2023. That was the date of the judgment. But very unfortunately, the judgment of this court, the apex court, was not placed for consensus. Other project, but the concept of the the for land loser, but this judgment was not placed before the page, a particular.
Yes.
Paragraph, page 19 of the judgment of apex court, I have handed over your lordship. What is the concept of this, your lordship? The page 9, the policy of the railway board, 9 of the judgment. If we go through how the policy was to be influenced, page 9, second paragraph. Yes, that I. The, eh, 2000, yes.
Everybody, some cases you are voluntarily saying that yes, we are going to call him for medical test. Some cases you are doing it after direction, and in his case you are saying Supreme Court. How can you do this?
I have tried to.
You are one and the same person. Lawyer may have different lawyers may appear, but the respondent is same. Respondent is same. In many cases, we have seen in that case, your authority has said, yes, it is not required. In WPST 88, there the Supreme Court judgment was not there.
No,
How do you do not know? You are railways.
Because in this matter,
You are railways. You can't say you do not know. You know.
Yes, that part, that's why I have.
Yeah, there is a question of looking into anything. It's only a case of discrimination. That is all, nothing else. Therefore, this order has been passed.
Yes.
This Supreme Court judgment must have been considered in some case by this court also. Must have been. So many hundreds of cases.
To satisfy the court, not in.
What satisfy? This is nothing.
Kindly see my lord order dated 27 February 2025.
Where is RB 99? Where is RB 99? Hmm. Yes, but they will get differential. I don't know those conditions, whether they are here we are concerned with the acquisition of the RU 99. That is a scheme of 8482. It's a different scheme. Can be. Therefore, where is RB 99?
Happy to, I do not find
Yes.
জিজ্ঞেস করতে দেবে তো কি বলবো? ইয়েতে আছে ট্যাবে ট্যাবে কালকে কিছু আছে অন্য কোনো জায়গায় আমার কোথায় আছে মে আই প্লেস মিলার
Hmm.
Different, everything is different.
99 million, I have got it not here. It is not appended here. I have got through mobile million. I can. I have handed copy.
What is it?
Copy is not appended, but I got to the mobile million.
What? RB 99. It is there. It is in the brief at page 49. RB 99 is enclosed. Type copy. Page 49, RB 99.
2010.
Yes, it is there. Not therefore, after seeing it, we are asking you. There is a stark variance in the two policies. The policy which was falling for consideration before the apex court was to give preferential treatment. Here there is no such thing. Here it is to give. There was a mandate that the candidate should fulfill. Here it is the candidate should normally fulfill. It's subject to relaxation, and your officer has already said that no, PET is not mandatory. Then how this judgment will help you? This will not help you.
See, one chance not to lose. See. Here. Under কিছু পাওয়া যাবে? Under কিছু পাওয়া যাবে কি?
No question of relaxation. Subject to relaxation. Here, there is give them preferential treatment. Here it is give them employment. Simple first.
Kindly one chance may be given because I try to I know everything. This is my maiden appearance before for the.
This is what more chance? We have seen it all. We are just curious to know whether this Supreme Court judgment has been considered in any case by this court.
Land to that case, I have got finally, let it be taken out 7th.
যত চান্স নেবেন তত
শেখার চেষ্টা করছি I am trying to learn something. হয়ে গেছে যাও।
Yeah.
I know the fate. Even Miller, they kindly allow me some to different.
List on third. As sprayed list on third. You file, why don't you file affidavit? Why are you giving like this?
I am paying leave to file by way of affidavit.
Yes. Now we have marked it.
And trace, I let it
Yes.
that I will trace by way of it.
In the meantime, we grant liberty. Or all right, we'll consider this. Don't worry. Third.
different person. So that guy put blood. The other not have been
34. ছিঁড়ে ফেলেছে ওটা নেই Yes, my lord, I for the petitioner, this matter was heard at length by your lordship, by this division bench. As to the son, your lordship directed the Mr. Mukherjee to produce any other judgment or
Lordship, I'm praying for short passover as Mr. Mukherjee is engaged in court number 8.
your lordship kindly see the last order.
Grateful. Grateful.
It is not today.
Not today.
$35.
35, I am for the petitioner, my lord. I pray for, I withdraw the writ petition, my lord.
What happened?
The petitioner not willing to proceed the case, my lord.
You are the advocate on record.
Yes, my lord. I am for the advocate on record.
You are for, you are not the advocate on record.
I am advocate on record, my lord. Sahriar Alam.
Give your appearance. Says that David was schooling. Schooling is corrected, he will get paid. With effect from 2000. But great. That advocate, Mr. So and so, learned advocate on record, submits that he is under instructions of the client that the client does not wish to pursue this matter. So he wants to withdraw the writ petition. The writ petition is accordingly dismissed as withdrawn. You are Mr. Sahriar Alam.
Yes, my lord.
$36.
Lordship, Mr. Tapan Kumar Mukherjee is appearing in this matter. He is on legs in.
Where is he? He is not appearing since 2 p.m. What is the matter?
Lordship, I've called sir's clerk on many times. He's on legs in court number 8, Lordship.
Affidavit has been given, reaffirmed affidavit. Reaffirmed. What is the issue? Good. So you don't want to have that employment. You don't want that employment.
That is the circular.
Where they have said regarding age bar. Reaffirmed affidavit in opposition is taken on record. Yes. Reaffirmed affidavit in opposition is taken on record. Which page? You are reading from which page? Paragraph 14. On 14, where does it say that you are
After 14, page 15, last two lines from the bottom.
page 15?
Para 15, page 6.
Where have they said you are over age? We are asking you.
But in case of compulsory appointment, Milord, age is not required.
Where have they said that you are over age?
Yes. Inquiry report টা কোথায় আছে? The inquiry report, Milord. Inquiry report টা কোথায় দিয়েছে? Page বল দেখিয়ে চাল না। Page 19, Milord. Appears from inquiry report. Right hand side, 1, 2, 3, 4. Not eligible due to overage.
So for constable, there is no requirement. Even under compassionate category, there is no requirement. Huh?
Yes.
Show it. Where from where you are saying? Show us. Which rule applies to this recruitment? Which rule applies to this recruitment?
memorandum state government issued the memorandum finance department that condonation of excess age in case of appointment on compulsory ground.
Again, we are asking you that in case of constable, there is no requirement.
No, there is no specifically stated, my lord, the constable or group D or group C.
So therefore, the memorandum that you are reading, that is for civil service or for police service?
No, appointment on compulsory ground, I am only one line. Compulsory ground being referred to finance department condonation of excess in age as prescribed notification required for the offering appointment. Matter has been examined simply by existing procedure. It appears that spirit rule 8 of WBSR part 1.
So WBSR, does it apply to police service?
WBSR in case PRB is there. But WBSR means in all case of the original government service.
It applies to police service. Tell us, we are asking you.
Even Millard, the WBSR is also applicable in case of police personnel.
It is, and for this is appointment under compassionate ground or under exempted category.
Compassionate appointment.
But it says exempted category.
The compassionate ground, condonation excess for appointment on compassionate ground.
It is governed by which provision? Which provision governs the compassionate recruitment in police service?
2013 circular is there. I have also annexed. And the compassionate appointment scheme. And there is a rules. The constable should not be not more than 27 years.
For regular appointment.
Regular appointment.
But not compassionate appointment.
Then I am assuming what is that? Kindly see 2010 notification issued by under the section 2 of the Police Act 1861.
16/7/2010.
16/7/2010.
Yes.
Not less than 18 years, 27 years on 1st January of the date of appointment.
We are not asking you what is the eligibility for appointment. We are asking you for compassionate appointment, what is the requirement?
There is no reflection.
For any civil appointment, nobody can just apply and get appointed. Post has to be notified, qualification has to be prescribed, eligibility has to be prescribed, then it is done.
Yeah.
But in case of a compassionate appointment, nothing is done. So therefore, the normal recruitment process means nothing. We are asking you under a compassionate scheme, where is the age bar?
Exempted category, government memo particular exempted category, under exempted category on compassionate ground. এই মেমোতে
কত আছে?
আমাদের কপি দিও আমি দিচ্ছি
কত?
27
our exempted category notification issued on 7th December 2022. 7th December 2022.
Which page?
That has not this. কত পেজ কত পেজ আছে এটা? এফিডেভিটে কোন পেজ আছে? Page 28 of my affidavit. Yeah. Have you also got it? Procedure to be followed for employment to the post of constable, rifleman, recruit rifleman under exempted category compulsion ground. In order to facilitate the process work of application for employment under exempted category and compulsion ground, post of constable, lady constable, fireman, recruitment police are now being requested to follow the procedure laid down under memo dated 1st December 2010, Home Department, 10, kindly see page 29, 1st December 2023. Then, kindly see page.
Next page.
Next page.
30.
Page 30. Rule 4 small b.
4D.
4 small b. Not less than 18 years and must be not more than 27 years.
And what is the date on which her case has been considered?
Hmm?
23.
Period কোথায় গেল?
It was after this.
Page R1, my lord, page 8. Page 8, R1. In Bengali, my lord, it is
What are you referring to? The opposition?
no.
They have applied on
Opposition,
22nd,
opposition,
2023.
page, opposition, page 8.
What is it?
Copy একটা লেখা আছে?
You applied in 13.
Yes, 27/11/2013. Then he was within the age.
Page 11.
Thereafter, my lord,
What is the date of death? Your husband died.
yes, 16/11/2013. Death certificate is there.
How could he apply? He became legally wife 2017. From a civil court got decree that she is the wife that in 2017.
What is the date of decree?
Just give me 1 second. Decree to date.
That is
9, 10.
18/12/17. Page, next page, 19.
And page 9, can you see?
Page 9, page 9.
Page 9. 18 December 2017. If she got a declaration that 18 December she is the legally married wife, then how could he apply in 2013?
No, as page 10, your lordship can see their opposition. Production of marriage and succession certificate or any order of competent court of law to the petitioner issued by the Superintendent of Police, Government Railway Police.
So the final application after everything is of 22/12/22.
2022.
At page 11 of the
Opposition.
yes, 22/12/22. Prior to that, there is no proper application. After declaration of marital status in 2017,
Then he got
this is the first application.
ফার্স্ট অ্যাপ্লাই করছে কনস্টেবলের কিন্তু মাধ্যমিক পাস করছে 15 সালে তাহলে মাধ্যমিক পাস করেনি তাহলে অ্যাপ্লাই করলো কি
And my lord, most interesting, she passed Madhyamik examination in 2015. How
she passed
Madhyamik examination, class 10 in 2015. And how could he apply? She could apply in 2013.
অনলাইন আমি জানি না, আমি বলছি না আমি জানি না। হবে কি ওটা? কবে 2022-এর অর্ডারটা করে না ও অ্যাপ্লাই করে বলেছে।
She wants, we should avail or she should leave it.
See page 11, when she applied.
That is what we are saying. We have just now, we have said she has applied on 23/12/22.
2nd January 2023.
22/12/22. Page 11 is 22/12/22.
Or 2023.
Prior to that, there is
Your
no.
logical is the page 34 of my application.
Obviously,
it
it appears that you don't need a compassionate appointment.
No, no.
Yes, it appears so.
Your logical is
It appears to us you don't want a compassionate appointment. So if you don't want, if you are not a needy person, then why? Just leave it.
Question of Milord.
They are asking you to give an application. You are saying, no, make me a constable.
Your logical is page 34 for a moment.
Yes.
Page 34.
Yes.
Please arrange to inform Shrimati K.R. Mojumdar such and such. To come to Reserve Office Howrah at such and such. Immediately to submit a fresh application, and this application must be mentioned the post. Your logical is Group C, Group D, and Lady Constable.
Correct. These are the, whatever it is, they have given you a letter which you have challenged before the tribunal. That letter is for offering a compassionate appointment. You don't want that. Then what is to be done? The letter that you have challenged is at page 71. Read the letter. What letter you have challenged? Either you accept or you reject. Why should you challenge it? They cannot be made to compromise on the police force. If it is a civil employment, it is a different thing. For police, the standard cannot be. It is not that they are not offering you a compassionate appointment. You want to avail the benefit, you avail, or you don't avail, as you like.
Terms of the notification.
All right.
The order Milord is applied Milord for the.
All right, very well.
Milord, your lordship page 35 also Milord. I have immediately Milord.
Nothing. You should respond to this letter if you want to. If you want to avail the appointment, you may respond. If you don't want to avail, you don't respond. But you must respond within 4 weeks from today. If you don't respond, then you will lose your chance. Heard learned counsel for the petitioner and the learned counsel for the state. The petitioner's claims to be husband of a government servant who died in harness while serving as a police constable attached to the Howrah GRP within bracket Government Railway Police. The death occurred on 6/11/2013. The authorities were not sure of the claim of the applicant and therefore required her to produce a marriage certificate or order of a competent court to support the fact that she was a legally married wife of the deceased constable Sujoy Majumdar. Deceased constable number 1566, Sujoy Majumdar. The applicant thereafter obtained a decree from the Court of Learned Civil Judge within bracket Junior Division, First Court at Howrah, on 18/12/17. Relying thereupon, she submitted an application for grant of compassionate appointment. In the meantime, she has also acquired the Madhyamik qualification, being a basic requirement even for grant of compassionate appointment. The authorities have considered her claim finally submitted after ascertaining that she has all the documents to support her claim. Submitted on date submitted on the 22/12/2022. Since the applicant's husband was serving the police force and her claim was being considered accordingly, the authorities found her claim to be covered by the decision dated 7/12/2022, issued by the Deputy Inspector General of Police within bracket P and W, West Bengal, regarding processing of application for employment under exempted category within inverted comma, under exempted category on compassionate ground, inverted comma close, to the post of constables, lady constable, rifleman / recruit rifleman, stop. The DIG has directed all concerned by this communication that for appointment to these posts, the procedure laid down in a notification dated 1/12/17, issued by the Home and Hill Affairs Department, Police Establishment Branch, Government of West Bengal. Full stop. The notification dated 1/12/17 contains the rules regulating the recruitment of constables and lady constables in the police force, West Bengal Police Force. Full stop. The notification has been issued in supersession of all earlier orders, earlier rules on this subject. The eligibility criteria is specified in Rule 4. Rule 4 within bracket small b reads, take it from page 30, 30 of the opposition filed today. Since the petitioner does not, since the age of the petitioner does not fall within this criteria,
she has not been found eligible for grant of appointment to a post of lady constable under the exempted category on compassionate grounds. Full stop. However, acknowledging the petitioner's claim for appointment on compassionate ground, they have issued a communication to the petitioner on 26/4/23 that since she has become ineligible for recruitment to the post of lady constable, she may submit her willingness in writing for employment under exempted category to the post of group within inverted comma D or within inverted comma LDC, full stop. Instead of responding to this letter for availing the benefit of compassionate appointment, she has assailed this communication by filing OA number 212 of 2024. Full stop. It is her grievance that she is not being considered for appointment as a lady constable by applying the eligibility criteria applicable to regular appointments. Full stop. Karachi. Insofar as the petitioner's grievance is concerned, we find the same not to be unsustainable. In case of appointments being made to a police force, the authorities have considered it appropriate not to compromise on the eligibility criteria having regard to the nature of duty to be performed by the constables. A conscious decision has been taken applicable uniformly to one and all that the eligibility criteria contained in the notification dated 17 वाला जो ऊपर में लिखा है will apply even in the case of appointment under the exempted category on compassionate appointment. Full stop. Being mindful of the need of offering appointment to the eligible legal heir stroke family member left in penury on account of sudden demise of the breadwinner while in harness, they have offered the appointment, they have requested the petitioner to make application for appointment on compassionate ground to other posts where there is no stringent requirement of possessing the requisite qualifications having regard to the nature of duties expected to be performed. Full stop. They have thus asked her to make an application for appointment under the exempted category to the post of Group D or LDC, which she has not availed of. The learned counsel submits that the petitioner was pursuing the matter being aggrieved by the fact that she was disqualified for the purposes of selection as a constable. Full stop. In view of the circumstances taken note of above, we find no infirmity in the communication dated 26/4/23 issued by the senior SRP Howrah, Subtenant Railway Police Howrah, to the petitioner. Full stop. Should the petitioner be desirous of availing the appointment, should the petitioner be desirous of being considered for appointment on compassionate grounds in terms of this communication, it will be open to her to make her application for the same. Full stop. We find no reason to interfere with the order of the tribunal dated 30/4/2024, passed in OA number 212 of 2024. The writ petition is dismissed.
Time period होगा, time period तो कुछ भी क्या तो बात नहीं.
37.
This one. Yes. Not today. All these matters, all the next.
38.
Yes, call 42.
42.
This is the matter where the PET is in question. Sure. From the affidavit, it was clearly stated that one of the person has been granted an appointment. My lord, ask the railway authorities to into that, my lord.
Who is appearing?
All these 7 matters.
All right, not today, let him be here. Next case.
Oh.
You want it on third? All right, as prayed, list on third. 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 You will be here. You will be here. Huh? Only this one.
Forty-three.
Call.
44. 45. 45. 45.
Not today only. I'm praying for not.
Call.
46. 47. 7.
Yes. And supplementary. Yes, my lord. This supplementary evidence has been shown earlier, my lord.
but it is a case of interest and gratuity, my lord. But as per your lordship direction, the delay part was there. And that one was annexed for that is in supplementary evidence order was passed, my lord. And page number 13, my lord, your lordship. And the supplementary evidence. Yes, my lord.
What is the date of the inquiry report?
Inquiry, my lord. Inquiry 15, my lord, 13.
Hmm?
That is my lord, page number 13. Page number 13. What is the precedence order, my lord?
Page number?
My lord, period of allegation. Page number 13. Supplementary.
1-3.
Supplementary. 1-3. Supplementary, my lord. The total description is there, my lord. Period of alleged misconduct 2013.
We are asking you what is the date of inquiry report?
Inquiry, my lord, 15, my lord. 15 was charge sheet was even an inquiry. Inquiry report.
When did you file your reply to the inquiry report?
Within due time when the proceedings were started and the inquiry.
Give us the date.
Date, my lord.
What is the date of inquiry report? When did you file the reply to the inquiry report?
Inquiry, my lord, date of submission of the inquiry report, my lord, page number 3. Page number 3, my lord. Page number 3, para 4, my lord. Date of issuance of charge sheet, date of submission of inquiry report, 23/2/2016.
All right. When did you submit your reply to the inquiry report?
Seats of the case. Reply, my lord, within time, my lord, that is. Reply to the reply. Appeal to the against the memorandum হচ্ছে reply to the inquiry. Payment. No, 27/15. DN on other than thereafter. Reply within 7 months. देखिए HON'BLE पे retired court not the appeal.
You have made out a case.
Yes, my lord.
That inquiry report was submitted in 2016. You made a reply. For 4 years, they have taken no action.
Submission of.
Therefore, for this period, you are entitled to interest on the gratuity.
There is the delay part on the administration, and that has been proved by the page number 13.
It will not be proved from page number 13.
As because it is precedent order, my lord.
It is not, it is nothing. The delay has to be seen from the date you submitted your reply to the inquiry report.
Now, when this immediately thereafter the inquiry report appeal was made, and thereafter the inquiry has been completed, my lord. Otherwise, how the completed, my lord? After the completion of the inquiry, my lord, the matter was sent. What is the delay, my lord? The matter was sent by the railway administration after 4 years.
So after 5 minutes, you are saying the same thing which we said immediately. That after the inquiry report was submitted, you say they have committed a delay.
No, my lord.
Yes, from 2016 to 20.
No, 16 the completed. It was completed. within the time frame, the 180 days, the inquiry was completed, my lord.
Correct.
And after the railway administration sent the matter to the railway board after 4 years, my lord.
That is what we are saying. After completion of the inquiry report, there is delay.
Yes, my lord.
So up to you, we have to tell you 3 times, then you will realize.
So that is it. Page number 13, my lord, is the evidence.
So inquiry report was submitted on 23/2/2016.
16.
The commission was sent the brief in 20.
As because the staff has retired for that is it was sent to the railway board. And the railway board matter was sent after 4 years from the date of inquiry.
When did you submit your reply to the inquiry report? Everything we have to ask you 10 times.
My reference is there on page number 36, my lord.
Date, when did you file your reply to the inquiry report? Then show us where you have mentioned it.
Against this report, reply দিয়েছে কোথায়? Let the matter, my lord, tomorrow, my lord, matter. I will inquire the matter.
That is the only question we have recorded in the last order. You have not you have annexed the order, still you are not ready.
Last order, my lord, to annex the
Can
precedents
you
and
understand this?
punishment of the.
Can you understand this?
I have understood, my lord.
You have annexed it in your what you are filing today.
If the railroad order has been annexing, it was not annexed and it was ought to have annexed, that further is in it was. That is why. ইনকোয়ারিটা কবে হয়েছিল সেটা দেখুন আপনি বুঝলেন ইনকোয়ারিটা কবে ইনকোয়ারি রিপোর্ট yes
জিনিসের আগের ডেট কি আছে
but send the matter to the railway board delay yes yes my lord.
Since last day we are asking you to find the inquiry report.
Yes, my lord, I'm verified tomorrow, my lord. Yes, my lord, I'll verify. Not if the reply was not filed, my lord, how the conclusion has been made? No, that day it was not annexed, my lord. Huh? ভালো করে দেখান চলুন তো আচ্ছা আপনার ফাইল দেখুন ভালো করে চলুন তো
48
49 lot. Let this matter be taken on 3rd July. 49. 3rd July.
50.
If my lords, if one thing, my lord, if my lord, senior my lord, take the instruction because this issue is already decided by this honorable court, by this honorable bench.
Yes.
I'll just provide my lord with the WPCD number. It is with yes, my lord. This is with respect to my lord the chief loco inspector's running allowance. So that is already decided. Yes.
I have some difficulty on tomorrow.
ওটা তো already decided হয়ে গেছে
হোক না you lord kindly take it.
My lord, lordship's judgment is of several others are there. I will be relying upon 12th February, which is accepted by them.
So they have complied with it.
Yes.
Let it come on 3rd.
As your lord.
Give him a copy so that he knows. The copy of judgment passed in
WPCT number 2 of 2025
has been handed over to the learned counsel for the petitioner. Since the same issue has been decided and implemented in favor of the petitioners therein as per submission of the learned counsel for the private respondent, we expect that the learned counsel for the petitioner will take instructions to ensure no discrimination in the matter. And the matter is taken up on 3rd.
The judgment is there in favor of the respondent there.
Respondent therein, yes.
Respondent there.
In favor of the respondent therein. judgment in favor of the respondents
Yes.
therein.
এই যে এটা রেখে দিন
49 কি আপনার
49
রেখে দিন ওটা রেখে দিন থাক
দেন না 49
ফাইলে থাক ফাইলে
আপনারটা আমাকে দিয়ে দিচ্ছি হ্যাঁ
নাম দিয়েছি? সবাইকার নামই দিয়ে দিচ্ছি আমরা দিয়ে দেন না, তিনজনের নামই দিয়েছি এইটা 49
দিয়েছো দুনিয়া দিয়েছো
বললো অর্ডার হলো পড়ে গেল যে
You are my other side. I didn't put it.
আরে সিগারেট খেতে খেতে ঠিক করবে হয়েছে হয়েছে আমরা